morning, ladies and gentlemen. Welcome to the South Carolina Public Service Commission's virtual hearing in docket number 2020-202-E. I will call this hearing to order. Before we do a roll call of the commissioners, please join me for a brief moment of silence. Thank you. We will take a roll call vote, starting with, a roll call to see who is present and joining with us. Starting with District 1, Commissioner Williams.
Commissioner Williams is present virtually.
Vice Chair Belzer.
Good morning. Commissioner Belzer is present in the hearing room.
Commissioner Caston.
Present in the hearing room.
Commissioner Irvin.
Present virtually.
Commissioner Thomas.
Present in the hearing room.
Commissioner Powers.
Present virtually.
And Chairman Williams is present here in the hearing room. All right, Attorney Minges.
Thank you, Mr. Chairman. Good morning, folks. This proceeding before the South Carolina Public Service Commission in docket number 2020-202E concerns the application of Duke Energy Carolinas, LLC for authorization to issue and sell securities. This matter has been scheduled for a virtual forum on October 22nd, 2020 in the Commission's hearing room and virtually. Mr. Chairman, the docket's in order.
All right, thank you very much. Who do we have joining us from the parties today?
Good morning, Mr. Chairman. For the company, I'm Sam Wellborn, outside counsel for Duke Energy Carolinas. Unfortunately, Katie Brown has some computer issues and she won't be able to join us this morning. I have with me Jordan Morgan, who's the Treasury Director. He'll be presenting some slides this morning, as well as Jack Sullivan, who's Assistant Treasurer for the company, and Bob Lucas, Deputy General Counsel. Thank you, Mr. Chairman, and good morning, Commissioners.
Thank you, Attorney Wilburn. ORS.
Good morning, Mr. Chairman, members of the Commission. Representing ORS is myself, Andrew Bateman. Mr. Chairman, I did have one quick point of clarification. Is this morning's virtual proceeding a hearing or forum?
It's a forum.
Okay, thank you so much, Mr. Chairman.
All right. Is anyone else joining us? Okay. All right, Attorney Wilburn, will you make the first presentation, please?
Yes, sir, Mr. Chairman. I'm going to try to share my screen. Hopefully I'll be successful with that. All right. Good morning, and thank you again. We're here to discuss matters addressed in docket number 2020-202E, which is the application of Duke Energy Carolinas for authorization to issue and sell securities. I've given introductions. This is the agenda that we'll go through if it pleases the Commission, and then we'll be happy to answer questions following the presentation this morning. I thought it would be helpful when we received the directive order related to the virtual forum to take a step back and take stock as to the various statutes and regulations that come into play as related to these securities applications. The law at South Carolina Code Section 58-27-1710 provides that utilities must provide or obtain approval from the Commission to issue securities payable beyond 1 year of their issuance. The next subsection, 1720, says that the application, which must be verified, has to include certain information, including the amount and character of the securities, their purpose, that kind of information. Section 1730 requires that ORS review the request and provide the results of the review. South Carolina Code Annotated Regulation 103-706 provides similar requirements, and I'll confess to you, Mr. Chairman, this morning that last night we also came across 103-823.1, which provides other requirements, and I'll say I hope in general that the commission finds this forum and presentation useful, but we would also offer to make a supplemental filing with the commission, sort of laying out in a clear way how we believe the application meets the requirements of 823.1. And so I'll just offer that now. I'm not asking for a response necessarily, but just wanted to mention that. More recent Duke Carolinas and Duke Progress dockets are listed on this slide and provided in the filed materials. These are just helpful in terms of background and the various types of filings that might appear in these dockets. This is an exemplar docket proceeding from 2016 for Duke Carolinas. The application was filed in February 2016, requesting authorization for $4 billion of securities. The ORS review letter was filed in February 2016. The commission approved it in March, and the company issued and sold securities as early as April and filed a report related to such. I'm not aware of a statutory or commission requirement, maybe there is one, that the company issue or file these reports, but they've done so just as informational purposes with the commission. Once that capacity was strained towards the middle of 2018, you'll see that in June, Duke Carolinas came in for its subsequent authorization to issue and sell securities. I'll pass things on now to Jordan Morgan again, who is the Treasury Director for the company, and he can give you sort of the inside business view of how this works on their side.
Sam, and good morning, everyone. So this slide 6 here just gives a high-level overview of the process Duke Energy Carolinas follows with its financing application and the securities it issues under the authority granted by the Commission. So just starting at the beginning, we file a long-term financing application with the Public Service Commission, and we also file a copy with the ORS, which gives them an opportunity to review and ask questions of the company from the filing. Once the Commission issues its order, we take that order and look at the requirements of the order and make sure that we are able, or ensure that we are able to issue our securities in accordance with the order received. Next, DEC will begin issuing long-term financing securities pursuant to the order. As we enter new long-term financing arrangements, the amount of that issuance is deducted from the remaining financing authority granted from the Commission. And as Sam mentioned, we file a notice to the Commission each time we enter a security that gives the details of that security that we entered, and also states the remaining financing authority that we have available to us. And then lastly, once we have issued that under that order, and we've determined that the remaining financing authority is no longer sufficient to ensure that the company can maintain constant access to the capital markets, we'll start this process over and begin working on a new financing application, which we're here talking about today. And Sam, if you'll turn to slide 7. So slide 7 here is just highlighting transactions under the financing order that we received, the current financing order that we received in August of 2018. You can see there in the top line of the table that we received an order for granting us authority to issue in aggregate up to $4 billion of securities. Since that time, we've entered 12 separate financing arrangements, primarily first mortgage bonds issued in the debt capital markets, and then financing lease agreements. And as I said, each time we've issued a security, it's deducted from the authorized balance. And as of late May of this year, we had approximately $375 million remaining in our authorized balance. You can see in the far right column there. And so that kicked off this process of beginning a new application and coming to the commission. So now turn to slide 8, and I'll turn the presentation over to our Assistant Treasurer, Jack Sullivan.
Thanks, Jordan, and thank you all for giving us the opportunity to communicate with you today, if virtually. This slide is just simply a summary of the request that we submitted a few months ago. As we routinely have over the past several cycles, about every 2 years, we look to the commissioners to approve our sort of next cycle of financing. And consistent with our 2016 and 2018 applications, we are seeking authorization for $4 billion for Duke Energy Carolinas. And that covers the same type of securities that have been included in prior recent applications, including long-term debt securities. Duke Energy Carolinas accesses the debt capital markets with a relatively large bond offering each year. In addition to that, it occasionally accesses the bank loan market. Depending on certain circumstances, it may access the tax-exempt market, although that hasn't been a market it's accessed in several years. But it certainly is something we continue to look at. And then, as you may have noticed on the prior slide, we've been quite active in financing through leases, whether they be real estate leases, such as the Metro Tower project or other pipeline projects that involve some lease financing. In addition to those types of securities offerings, the application also summarizes how we periodically engage in interest rate risk management transactions, and that's really where we are entering into a contract with a bank that typically locks in or caps our exposure to changes in interest rates to try to minimize volatility for our customers. That, I believe, concludes our prepared remarks, but I do know that there were a couple of questions that were submitted, some topics that you'd want to further discuss, one of which was, we're asking for a relatively large amount of financing authority. We recognize that $4 billion is it's a pretty large headline number. You want some additional color as to the use of proceeds. What do we do with that type of capital? And we also heard there was a question about the timing of this authorization and potential consequences if it were delayed. And happy to get into that with you as well. But maybe before I go any further, I'll just take a pause and see if we're heading in the right direction, or if you had any questions based on some of our prepared remarks thus far.
Questions from commissioners?
Mr. Chairman.
Vice Chair Belzer.
Thank you. Good morning, gentlemen. Thank you for the presentation this morning. I would ask that you go ahead and make remarks regarding any possible impacts from the delay, any delay in issue. I think that's one of the points covered in regulation. It's either in Regulation 103.823.1 or one of the statutes. So if you could go ahead and address that remark. And that's it at this point. Thank you very much.
Thank you. Yeah, I'll be happy to take that one. I would say, I forget the date of the actual application. Maybe Sam or Jordan, you've got that handy. I want to assume it's been a couple of months now. Yeah, okay.
The application was filed on August 21st.
Okay, thank you very much, Commissioner. What we typically do, and maybe we can cue back to the slides that had the 12 different securities offerings that we sort of sold under this shelf, if you will. And I think what it show is by May, we found ourselves sort of sub 400 million, which means we had sort of whittled away at about 90% of the existing order. And that's often a trigger for us to go and submit a new application to, sort of refresh the coffers, if you will. Typically, these types of transactions have been approved within three or 4 months or so, but I guess that's not really the point. I guess the point is, if it were delayed much longer from where we are now, we would find ourselves in a situation where we could be facing a liquidity squeeze on the utility. Duke Energy Carolinas is in a very heavy capital spending mode right now, as we are making significant investments in decarbonizing our generation fleet, and there's a significant amount of capital being deployed to transition our generation fleet to more renewable resources. There's also a significant amount of spending going on for coal ash remediation, so I know you're aware. And so on top of that, we also have other existing debt at Duke Energy Carolinas that is coming due, and obviously satisfying that principal repayment of existing indebtedness is pretty important. Not being able to do so would put the utility in a situation of insolvency, and obviously all of the knock-on effects to that. So I guess in a nutshell, our plan for Duke Energy Carolinas is to be ready to access the long-term capital markets as early as January of 2021. We've actually routinely hit the capital markets in January for our utilities, including a $900 million transaction in the first week of January for Duke Energy Carolinas. So if we were to not be able to do that, I think it would start putting the utility in a bit of a liquidity squeeze by that point.
Thank you for that response.
Mr. Chairman.
Commissioner Thomas.
Thank you. Thanks for the presentation, and thanks for being here to help us better understand what's going on with this financing. Just a few questions for you. So this shelf registration, I suppose, is a subset of a larger shelf registration. Is that correct?
That is correct.
So when was the beginning of the larger shelf, and what's the ending time frame on that?
I'd probably punt to Bob to help us out with sort of our more universal shelf for accessing the capital markets, especially SEC registered securities offerings. Bob?
Good morning, everyone. I am in-house counsel at Duke Energy Carolinas and help out with our financing arrangements. Referring to the shelf as an SEC shelf registration statement, we typically file a large shelf registration statement every 3 years because that's what the SEC regs require. The expiration of that is a 3-year cycle. In our case, we file a registration statement that allows for securities to be issued by Duke Energy Corporation and each individual utility subsidiary owned by Duke. So to to that extent, it is a larger shelf. The SEC these days doesn't require you to specify an amount of securities that is allowed to be issued under that shelf registration. Rather, it's just this timing cycle. So, from an SEC standpoint, the shelf registration that we have is unlimited in amount. But as we are talking about here, you know, we get an amount authorized from a regulatory commission standpoint for each of our utility subsidiaries.
Okay, with regard to...
Does that answer the question?
Yes, so with regard to the $4 billion that you're looking at right now, so does that one have end date on that? Does it terminate at some point? Just when it's all gone?
Yes. What we've done in the years since the SEC has gone to this 3-year life of an SEC shelf registration statement is just refiled on that 3-year anniversary, and current SEC shelf that we're operating under was filed in September of 2019. So we've got that one active and able to be used until September of 2022, at which time we'll merely replace it with an almost identical filing.
Okay. So I see that you have some discussion in connection with the interest rate management agreements, and it looks like that you have used and intend to use some fairly sophisticated products. So I'm just wondering, when did you start doing this?
Thank you. I believe we've been engaged in interest rate management at Duke Energy Carolinas for at least a decade. I've been in this role for 5 years, and I know that my predecessor periodically entered into typically treasury locks. These derivatives try to make it sound complex, but it's really not. It's just looking at the underlying treasury rate at a given time and knowing that we have a securities offering within the coming year or so, and knowing that the treasury rate as of the time that you can go ahead and lock that in, would be deemed a prudent corporate finance decision. So, I would estimate it at least going back a decade.
I'll say, Mr. Commissioner, that, in previous dockets, and we can provide cites to the extent it's helpful, but the Commission has previously provided approval for those interest rate management agreements.
Okay, so who are some of the key financial institutions that you work with on these types of management agreements?
Sure. We have ISDA agreements in place with probably a half dozen at Duke Energy Carolinas. I don't have the full list right in front of me, but they would be all institutions you would be familiar with. Banks such as Bank of America, Wells Fargo, J.P. Morgan, Goldman Sachs, Scotiabank, U.S. Bank. Those are some of the more common ones we look to for interest rate management.
Okay, and so basically you've done this for a long time with some well-known institutions, and so have these always played out to where they save ratepayers money, or have they occasionally gone in the wrong direction?
Yeah, it's a mixed bag. I would say you always enter into a treasury lock when you find that doing so mitigates risk, and you're perfectly fine living with that rate. There are circumstances in which the rate continues to grind lower, and you're left playing a little Monday morning quarterback that, gosh, we shouldn't have hedged, and it could have resulted in a lower rate. But there's also examples where you say to yourself, it's a good thing we hedged because we doing so saved interest expense. But, we always look at it as you enter into a rate lock when living with the consequences of that is good for the customer. I'm pleased to report that as of today, Duke Energy Carolinas has $11.4 billion of outstanding long-term debt, and its weighted average coupon. This isn't going to directly link up with anything in prior rate cases because it moves around every time you calculate it, and I'm just looking at long-term debt, bonds, not bank loans and other forms of financing. But Duke Energy Carolinas has a weighted average coupon of just over 4%. So regardless of whether or not there have been interest rate hedges that have worked in favor, or you may have left a couple of basis points on the table. We've got one of the lowest costs of capital for Duke Energy Carolinas on the long-term debt side. Given that interest rates now have ground down to an even lower level, we may look to de-risk and lock in some of those attractive rates in the coming year or so.
Okay, so it sounds like with the current low interest rates, you think there's a real opportunity to get into more of this. Is that correct?
I wouldn't necessarily say get into more of it. If what you meant there was doing it more frequently, no, or doing it in larger size, probably not. What we traditionally do is we never hedge more than 50% of what we intend to raise, so that you haven't gotten into a situation where you're trying to hedge more than you potentially could end up issuing. So we typically look at what amount of capital we're going to raise, and if the forward curve suggests that there is some potential risk or volatility, we would look to de-risk a portion of that. But we wouldn't do anything to the current rate environment isn't likely to change sort of our interest rate management policies.
Okay. I see per your Exhibit H that you have about $2.3 billion touring in the period 2020 through 2023. And do you expect to use some of this tranche to refinance those at lower rates? Is that part of what's going on here?
Absolutely. That's one of the key drivers of, one of the things, probably the biggest component of seeking financing authority is to refinance maturing debt. So for every dollar of debt that matures, in order to preserve our regulated capital structure, we need to refinance maturing debt into new debt. And of course, in this lower rate environment, we're going to be saying goodbye to higher cost debt and refinancing it with lower cost debt.
Okay, and so are you expecting to refinance at maturity or before maturity?
Most of the debt that is maturing in the next several years don't allow you to prepay without a penalty. So what we typically do is we refinance the maturing debt within about a 3-month period of the maturing debt's maturity date.
Okay. And it looks like you expect to spend approximately $16.2 billion in the period 2020 through 2024 for electric plant and other capital projects. So obviously this shelf will not be enough to cover that. Any thoughts on how that gap will be bridged?
Yeah, if the 2016 $4 billion financing authority was exhausted, well, not exactly exhausted, but we whittled that down to the point where we were back in front of this commission by 2018. And of course, as we reviewed in the prior slide, the 2018 authorization got us to mid-2020. I would expect that we would be back in front of you within a 2 to 3 year period, giving you a status report on what all we, how the prior authorization was sort of whittled away, and proposing a new financing authority at that time.
Okay, and so I assume that with that $16.2 billion, that some of that will be invested in North Carolina and some in South Carolina, and obviously those investments appear to like they will be funded at lower interest rates. So how is that benefit allocated to South Carolina ratepayers?
Sure. I mean, each time we refinance higher cost debt with lower cost debt, that sort of brings down our weighted average cost of debt. Therefore, each subsequent time we come in for a rate case to revisit the revenue requirements, that lower cost of capital will influence the rate setting process to the benefit of our customers.
Okay, but there's no real specific tying of a project to interest rate that may impact
Correct.
South Carolina instead of North Carolina.
Correct.
And I think that you alluded a few minutes ago that that there are make-whole provisions with regards to most of this debt, so it's probably a bit problematic to retire early. Would that be correct?
Yes, sir. Particularly in this low interest rate environment, sounds like you know a thing or two about make-whole premiums, and the present value of those discounted cash flows would be discounted at a considerably low interest rate, and as a result, the premiums to pay to get out of those loans or bonds early would be a pretty hefty premium. If we had debt that was priced at 7, 8, 9%, we may look at ripping the proverbial Band-Aid and paying up for that premium. But given that our weighted average cost of debt for Duke Energy Carolinas is already pretty low at just over 4%, we'll just naturally let the debt continue to mature. And as you would expect, every year we face maturities with the goal of refinancing maturing debt over the next several years at lower rates.
Okay. Well, I appreciate that. Appreciate you helping me walk through this a little bit, and thanks for being here and helping us out. That's all I have.
Thank you.
Thank you, Commissioner Thomas. Other commissioner questions?
Chair Williams.
Commissioner Caston.
Gentlemen, I too want to thank you for the presentation. And earlier you had said that whether ratepayers would benefit or not was sort of a mixed bag traditionally. Was there, any study or benefit cost or whatever on this particular issuance that would indicate whether this would be positive toward ratepayers, negative, neutral?
If you're referring to our ability going forward under this application that we're seeking, I would feel fairly confident that the debt that we will be issuing, the securities that we will be issuing under this current application would allow us to refinance existing debt at a lower rate, which would accrue to the benefit of North and South Carolina customers.
Yes, thank you. That is what I was asking. I appreciate that. And I know you've pretty much answered this relative to the capital projects that you have planned. relative to this particular issuance, is there a certain percentage, how much of this would go to specifically to capital construction? And what are those construction projects specific over that period of time? Do you have an idea of what those projects would be? You had mentioned
Yes,
some
sir.
decarbon projects, but I mean, what is that?
Yes, sir. Yeah, we have a capital expenditure schedule for each of our utilities, and we typically break them out into a couple of different categories. Specific to your question, the components for Duke Energy Carolinas would involve, let's say, for example, 2021 spending of approximately $2.8 billion on.
Mr. Chairman?
I'm sorry.
I'm sorry, Mr. Sullivan. I hate to interrupt, but Mr. Chairman, information is being, collected and disseminated in this forum. It's outside of a formal proceeding. ORS would like to raise not a concern about the information necessarily, but just about this process. Additionally, ORS is a bit unsure as to the nature and purpose of the forum.
Okay, so did you just want to put that on the record, or do you have a specific objection?
Well, I would like to note the concern, certainly, Mr. Chairman. I would also like to note we're unsure about the nature and purpose of the forum. I wasn't sure if clarification could be provided.
The company presented an application or request for approximately $4 billion in capital or issue securities, and the commission had questions about that. And so the request was made from the commission for the company to come in and give a presentation to give more detail on their request.
Okay. Mr. Chairman, one concern is that it appears in some form or fashion to be a bit like an ex parte communication. They're not necessarily bound by the parameters set forth in 58.3.260. And so ORS would like to raise just its concern about the nature and purpose of the forum itself. Thank you, Mr. Chairman.
I'll offer, to the extent it helps issues or concerns, we'd be happy to file an informational report with the commission and the docket, particularly as related, as I mentioned before, 823.1. I was also getting a little nervous, I'll say, about the potential overlap in terms of long-term projects and the pending IRP dockets, and I was sort of close to pushing the button myself, so I don't know if that helps this conversation or not, but like I said, to the extent we're edging into project planning and those kinds of issues, I might have a reservation as related to the pending contested IRP dockets. And again, we're happy to file a report as related to 823.1 that might help, answer some of these questions if that helps at all.
Well, I definitely appreciate both lawyers paying close attention to what's being discussed here today to make sure we're in the bounds of the rules. With that said, has any question been asked or answer given that has crossed the line?
Not from my perspective as related to the IRP proceedings, but, I would make that caution, I guess, that we have to be a little bit careful talking about long-term project planning, given those pending dockets.
And Mr. Chairman, I would just once again echo the concern about information being collected outside of a formal proceeding and the purpose for which it's intended to be used, as well as just I'm just unsure about the nature and purpose really of the forum. With an allowable ex parte proceeding, there are a number of parameters and guardrails intended to ensure that the APA is complied with and the other statutory provisions. And so, Mr. Chairman, I don't know that I have anything specific to point to, but I would echo the concern about not the information being presented itself, but rather the purpose for which the commission is intending to use that information, as well as just some unsurety about the nature and purpose of the forum. Thank you.
Mr. Chair, if I may elaborate.
Sure, Commissioner Caston.
My purpose is solely just to understand better. I don't want to get outside the bounds of anything I'm not supposed to. Other than that, I've reviewed the presentation, I've listened, and it's triggered thoughts, and I'm just simply trying to understand better. That said, may I ask another question?
Commissioner Caston, and so Attorney Bateman, Attorney Welborn, this virtual hearing is not scripted. So if you hear a question or answer that you believe violates the rules, I'm asking for you to make an objection and request for it to be stricken from the record.
Well, Mr. Chairman, one point of clarification again is to ensure that this is not a hearing, but rather it's a forum. I've heard it referenced as a hearing a couple of different times, and I think that is causing a bit of confusion on our end.
And I'm glad you pointed that out. It was just pointed out to me. I'm saying hearing. It's a virtual forum.
I understand the direction, Mr. Chairman, and I'll keep that in mind as we move forward.
It was just pointed out to me that you all may not know that it's being recorded and there's a transcript available. I don't know if that makes any difference to you or not.
Mr. Chairman, are the commissioners planning on using the information gained in this forum on which to base their decision?
No.
Okay. Thank you, Mr. Chairman.
May I ask the question?
Go ahead.
Looking at the legal and regulatory background slide, the last item, and I was just trying to understand this because I'm not an attorney in the group, so any attorneys here, make sure that I'm doing this right because I don't want to do it wrong. And I apologize if I've done anything that remotely looks that way. And I think the presentation's been very good. The responses have been good. Thank you very much, all of you. But it refers to Regulation 103-706 provides analog requirements. And I was trying to understand really what that was and how that related to this. Just out of curiosity, I'm trying to educate myself. So can you elaborate on that, just for my edification?
Sure. Yes, sir, and this is Sam Wellborn. So there are requirements in the code, that 5827-1720 section, that lists a set of items or information that the utility must provide the commission as part of its securities application. Those requirements are essentially repeated in 103-706 within the commission's regulations. So, for example, the amount and character of the securities, the purpose for which they're to be issued, those kinds of things. Those requirements are in 103-706.
And as I understand it, 706 relates to water or water utilities, but it's applicable because of the process. Am I understanding that part correctly?
That's right, Commissioner. They're comparable requirements in 706. But I had also mentioned before 823.1
Yes, sir.
and in our offer of, providing supplemental information related to that regulation.
All righty, thank you very much.
Thank you.
All right. Any other questions for the panel from the commissioners? Okay, any further comments from the parties? All right.
No additional comments from ORS, Mr. Chairman.
Okay, thank you, Attorney Bateman. Attorney Wellborn?
Nothing for me, Mr. Chairman. Thank you.
Okay.
Appreciate y'all's time this morning. I really do.
Okay. Everyone that joined us today for this virtual conference, it's not a hearing, forum. Thank you very much, and we appreciate your time.